discussion as well. The other thing that I want to say is, in terms of etiquette, we're very happy for you to tweet out during the course of the discussion. And if you can tag us in, then we're very happy as well. So for Leopoldo, it's Leopoldo_Parada. And for the seminar series, it's UOE CJS. Thank you. So without further ado, I want to give a very, very brief introduction to Leopoldo, who very kindly responded to me through the Twitter sphere when I retweeted and suggested that he could give a talk, which started off with the idea of it being directed primarily at students with common interests at Leeds and at Edinburgh, but it's grown since then to be a fully public seminar. So I'm very grateful to Leopoldo. And just so that you know who it is that's talking to you, Leopoldo is a lecturer in tax law at the University of Leeds and has been there since 2019. And he's worked on the latest release of Pandora Papers, and that's going to be his topic for the day. He has previous academic and practitioner work in a number of jurisdictions. He's worked in Italy, the Netherlands, Germany, Chile, Brazil, and the US. And his PhD on tax law is from Valencia, and it was awarded the top tax law PhD award in 2018 from the University of Paris Sorbonne. Leopoldo is going to talk for approximately 20 minutes, after which we will be opening the floor for discussions. So Leopoldo, without further ado, I'm going to take my slides down and hand the floor over to you.
Thank you very much, Andy. Thank you very much for the invitation to be here today. Actually, it's fascinating for me to mix up a bit of thoughts from people from different areas about these Pandora Papers. But there is another thing, of course, which has to be with the fact that I was directly involved in one of these stories. I don't want to take much credit about, because my participation was mostly about reviewing some confidential documents and advising the journalists in terms of what were the legal implications of some particular transactions, in this case related to Mr. Andrej Babiš, the Prime Minister of the Czech Republic. But for today, I don't want to focus so much in the story of Mr. Babiš, although we can come back to that later on. But I would like to give you a bit of my thoughts on these Pandora Papers in general. Because if we come back to the 3rd of October, where the International Consortium of Investigative Journalists released this story of the Pandora Papers, and it provoked immediately a major change. This is something different to what we have witnessed before with all the leaks, like the Panama Papers or the Paradise Papers. Not only because here more or almost 12 million of financial records were released, it also involved a very high-profile personalities around the world, including politicians, celebrities, royal members, and in general, very wealthy and powerful people. Now, of course, the reactions to this didn't wait, and we sort of witnessed the polarization of the debate. On one side, those who were basically condemning the leaks, saying this is shameful, it's a shameful example of a violation of privacy. On the other side, we have those which were, to a certain extent, applauding the courage of this group of journalists who played their own cards against the elite, and is, let's say, permanent use of offshore industry. But there is one characteristic that it goes completely transversal to this debate on whether we protect privacy as an absolute value or whether we applaud what this journalist did. and it's the fact that almost all, if not all, of the financial transactions that they were disclosed within the Pandora Papers are within the scope of what we could call legal behaviors, according to current laws. And this is very important, and it's very interesting to understand, because unlike some other commentators, I think this shouldn't be taken as a justification of the conduct disclosed within the papers, but rather as a sort of a wake-up call that allow us to understand, to a certain extent, the legal and social implications of the papers. In my view, these legal and social, mostly social implications, can be summarized in two, although there are all the social implications. Let me first refer to the legal implications. Legal implications, we don't have many, because the law is what it is, and if we want something different, we need to change law, right? So, of course, there are situations in part of these stories that they are strictly illegal. Just referring to the case of Mr. Babis, the whole transaction that was created to acquire this huge real estate in the south of France was not illegal at all. What was illegal was the fact that under law in the Czech Republic, he was obliged to actually disclose that property as part of his participation as a politician and in the particular election as president, as prime minister. But if we focus on the transactions, they were not illegal. Now, this, as I said, doesn't mean that we need to justify this and say, well, as nothing included in the papers was illegal, so we shouldn't care about this. Totally the opposite. I think there are two main lessons that we need to learn from these papers. One is referring to the fact of this global shift in the balance against the elites offshore industry. And I would like to clarify first that neither offshore nor tax or financial structure should be taken per se as synonyms of something illegal or against the rule of law. It's the law itself which allows cross-border transactions and the establishment of offshore financial structures as well. What I'm saying is that the fundamental question here is not anymore the distinction between legal or illegal. It's actually something more fundamental, which is who is actually making the laws and to which extent those laws are serving equally to all members of a particular society. For those of you that are not familiar with the book of Caterina Pistor, The Code of Capital, I recommend it to read, because in that book, she actually presents this idea that some laws seems to be especially tailored for some elite groups in a society, generally those people that they have access to more information or actually that they have more wealth. This is precisely what the Pandora Papers are doing. They are disclosing to us a pattern, a particular pattern on how laws can work in the benefit of a few members of the society. And this has worked very well so far. Therefore, when you listen, commentators saying, who cares if none of the transactions or most of the transactions in the Pandora Papers are not illegal, this is exactly a reflect of this pattern, and shouldn't be taken neither as a defense of the legality or illegality of the leak or as an argument to justify the content. Again, in contrast, I think it is a wake-up call to tell us, that the lawmaking process is or should change because it seems to be disproportionately disbalanced in favor of a particular group. What is the consequence of that? It's very simple. If people, they don't trust the laws, they can ultimately, or this can ultimately jeopardize democracy as a whole. This has been very well explained by Caterina Pistor in her book. The second major, I would say, lessons from the Pandora Papers is what I would denominate the cause of social shaming. The Pandora Papers demonstrated how reputational impact matters and how some already have assumed this cost. If you think about the case of Andrei Babis, for example, he lost the re-election. Right?
Yeah, literally, my volunteering person was there. Can we have a quick chat on it?
The re-election, sorry, I had to mute someone because he lost the re-election right after the Pandora Papers were released. The president of Chile is potentially facing a constitutional trial before he finishes his period as a head of the state. So these are consequences of social shaming. And in this regard, I believe that this is extremely positive. It's positive because secrecy, as a commodity potentially marketed among jurisdictions, does not only refer to hiding money or assets in order to ultimately pay less taxes. It's more than that. It may well serve the purpose as well of, for example, financing major international crimes, including terrorism, human trafficking, or any other. That is why I believe, and I'm totally convinced about it, that the cause of social shaming it should be internalized by countries because it represents a major step forward to prevent and to counteract more effectively future international crime. Now, many of you could think at this point, well, is it enough with naming and shaming? Of course not. It's not enough. We know that it is these two main lessons, the reputational cost, the shift in the balance against the elites offshore industry introduced by the papers, are or will necessarily or needs to be necessarily materialized in a major legal reform, because it is the change in the law what will make actually the change in what we do. What we have in front of us, however, is a very interesting full picture of this particular pattern. So it is up to us to take it or not. So that's why I also believe that all of this discussion about whether we should blame the law before because the law failed, or we should actually consider that the law was imperfect before, is not true. The law did exactly what it had to do according to what were the social priorities by then. The thing is that now our priorities have changed, and this has been demonstrated because of the reactions to the Pandora Papers. Today, people are way more aware about, let's say, the moral components of law, especially tax and financial laws. Therefore, it is now time to reflect that also in our own legislations. There are other minor implications, social implications related to the papers. For example, the proliferation of whistleblowers. We live in a society where technologies has allowed to protect people that they disclose information. If you just remember years ago, the case of the Falciani list, Mr. Falciani is still facing legal problems. Today, most of the people that they disclose information, the whistleblowers, are protected because we still don't know who they are. Of course, this puts on the table other interesting debates, which is the balance between legitimate privacy and common interest, but is another of the implications that we have. I do believe as well that the papers, they sort of change our understanding of the role of tax havens in a global economy. For those that are familiar with the terms, generally tax academics, tax lawyers refer to tax havens, those countries that they offer very low tax rates. They also offer some elements of secrecy associated to their laws in order to avoid taxation. But I could say after the Pandora Papers, we have realized that tax havens are not only places with low income tax rate and possibilities for tax avoidance. They may also serve the purpose of keeping members of a society outside of the rule of law, completely outside of the rule of law, which ultimately may generate more economic and political inequality. Finally, I would like just to say that the traditional boundaries between what is legal or illegal, or what we tax academics distinguish between tax evasion and tax avoidance, is not what matters here. It's not what matters in this particular league. Because the question today, it seems to be more about what is morally acceptable. And this puts, again, the emphasis into the tax morale, or the moral aspects in the creation of the laws. Just to finish and really to leave time now for our discussion, I would like to conclude with a very brief remark, which is that if you generally look at the Pandora Papers, they are more than a bunch of private financial documents that they represent isolated, sometimes abusive business transactions. They really show us a pattern on how laws work for the benefit of some groups of the society over others. In other words, it's revealing us the forest behind the trees. It is up to us now to decide what to do next. But the big picture is there in front of us, and it is then our decision what will be the next step. I will finish with that, Andy, and I'm very glad to open the debate now.
Okay, thank you very much, Leopoldo, for that very efficient run through of some of the issues. And so at this stage, we would just open it up to people either to raise their hands, not physically like I'm doing it, but virtually with the button at the bottom of the screen, or to put in comments or questions in the chat facility as well. And we've got our first question already in the chat facility. So Raj is asking whether tax evasion is one of the main reasons behind the financial secrecy. And I guess this comes to the line between evasion and avoidance that you alluded to at the end there. Or is it primarily, I guess it's the motivating factor. Is this just about avoiding tax, or how much is it about non-disclosure, as seems to have been one of the issues in the Babis case that you were talking about there?
Yes, I was on mute. Thanks for the question. I could say that this is really not about, not mostly about tax evasion, or mainly about tax evasion. And it's quite important, the question you raised, because generally we have to distinguish for legal terms, right? What is tax evasion is something illegal with tax avoidance. It is not illegal, but it is a law in itself that it will give the frame where a particular taxpayer can move around, right? So there is a little scope for the taxpayer to arrange its business in a way that is more effective from a profit perspective, and that is recognized in most jurisdictions, right? The law will say this particular conduct is abusive. That is, let's say, illegitimate tax avoidance. Whatever is not that is legitimate tax planning. But what we are witnessing with the Pandora Papers is something that goes beyond that question whether something is legal or illegal. It's about how is it possible that the very small group of people around the world, they can arrange the businesses in such a way that is completely legal and allows them to sort of go away with murder? And the law allows that. And I have to repeat that plenty of times. The law allows that. So if we focus the question whether the transactions involved in the different stories of the papers were legal or illegal, we go into the wrong question, because the question is, what is this showing us? It's showing us a particular pattern of design of the law, of how we make the lawmaking process. So if the laws are designed in such a way that they are allowing that a small group of people are doing certain transactions without having any implications, is because, and concentrating more and more wealth, is because there is something that should be changed. And that is perhaps something absolutely outside of the distinction between legality or illegality of the transactions.
Okay, thank you. And I can see that Sapna has her hand raised. Hi, Sapna.
Hello, Andy. Thank you so much. And thank you, Dr. Parada. I absolutely agree with your analysis on the political economy aspect of how law allows concentration of wealth on the hands of the few, and then the rest are obviously taxed and have to obviously adhere to the legal provisions. But I was struck by your observation on two fronts. One is that we see that in relation to Pandora Papers, of course, elite few, they are able to accumulate wealth. But on the other hand, the fact that you and the investigative journalists were able to publish the material that you have collected, it also shows the other side of law, right? Like, it also empowers. So if you're talking about law and the nature of law itself, then we can see this dichotomous identities of law. So going with that observation and to your conclusion as to what you were saying as to how you would like to see reforms being brought in this area regarding tax law, I wondered whether your sentiments are just in relation to tax or whether you are actually disillusioned by law as a tool. Thanks.
Thank you very much, Sabna, for that question. Yeah, I think you are totally right that there is this dichotomy, and I tried to avoid it during my presentation, but you catch it very well. Because of course I have talked about this issue with colleagues, that they are in the area, for example, of media law and privacy, and they say, how is it possible that information that is private information of people is disclosed in such a way when the public opinion is not a court? This is not the way of doing things. I do agree with the argument from a legal perspective only. I don't agree with the argument from, let's say, a more philosophical perspective of what is the society we want to build. So I do believe that things needs to be done within the, let's say, the borders of the law, right? I particularly participated, helping in one of these stories. I had access to confidential documents. Some documents were public, and not all of them are strictly confidential. It's not that my role was a sort of 007 agent. No, some documents are really easy to get, but some documents, is true, were confidential. But how I try to see it is, what is the ultimate role of this? What if this didn't happen, for example? Are we really capable of realizing this pattern? Because it's very difficult, to argue that there is a pattern when you cannot show this evidence, right? And this is done fantastically by the Pandora Papers. Because it's not that you have one isolated jurisdiction. No, you have the whole world working in such a direction, and laws generally are being done in a particular way. been shaped in a particular way. So I don't know how to solve that dichotomy, Sapna. I could lie to you if I said I have no idea whether we need to give an absolute value to privacy, or we need to consider it, as something that can be more easy to skip. I really don't know. From my perspective, as a tax academic, of course, I see, well, if we are not breaking any laws in terms of disclosing this information, there is a major gain that we are getting here. And without this, it would be very difficult to convince others about what is going on. So that's how I see it.
Okay, thank you, Leopoldo. Thank you, Sapna. So I've got a couple of questions coming up in the chat box, and then we'll go to Miguel, who's got his hand up. From Naila, she's saying that because this is quite common in many countries, particularly with people with wealth, richer classes, should there actually be a highlight on those people, more scrutiny of those people, perhaps different mechanisms for that? And if I can abuse my chair's position here and maybe say, are there any particular countries that you would highlight that actually have good practice around this, where that kind of scrutiny or tighter disclosure is there? Or she suggests then what kind of potential reforms would we be looking at if it's not about the scrutiny, but it's actually about the tax framework itself? So that's Naila's question. First, more scrutiny. Second, actual tax reform.
I don't have much to say about the scrutiny, to be honest. I couldn't name a particular, well, I don't want to name a particular jurisdiction. But because there is one thing that we need to understand as well, which is that generally in tax and financial matters, of course, each country is sovereign to decide what they want to do, right? So it's not that countries, they need to be coordinated in this direction. But there are some major steps that they have been taken in the last, I would say, 10 years. Starting from this OECD project, the Base Erosion and Profit Shifting project in 2013, that represented a major reform, internationally speaking, avoiding issues of tax avoidance, exchange of information, coordination among countries, and reallocation of profits among multinationals, because businesses are done today in such a way that you can have a headquarter in the US, but plenty of subsidiaries all around the world, and some branches and some very intricate structures, that I've seen myself also in practice. And now these rules are to a certain extent changing in a direction that at least in the paper tends to be more tends to be fairer. I don't think that there are a lot of points of criticism as well in what's going on at the international level with these particular reforms led by the OECD. But I think it's a step forward, in terms of how we change. Now, the law change only to the extent that we change, so our conduct change, right? So when people ask me, who cares about these papers, or about the Panama Papers, or the Paradise, or Luke's papers? I would say, well, if we internalize the message, of course, people start demanding better laws, because it's not that the law comes before and we adapt to that. It's actually our behavior who is then being reflected in a particular law. And this applies, of course, to tax laws. And yeah, Andy, I'm sorry.
Yeah, and if I can ask a cheeky follow-up on that, then. I mean, we're speaking about the law, yeah. And we might think of that as what is written down and the guidance as to what should happen. But of course, there's a matter of enforcement here as well.
Yeah.
So there's to go to a specific case, the Organized Crime Reporting and Corruption Reporting Project was discussing the purchase of some villas in Croatia yesterday. Now, these villas have had significant tax breaks because they were designated as tourist facilities. but there's very little evidence that they have been used as tourist facilities. And there's lots of evidence of complex money moving around and ex-Russian finance ministers and Putin's masseuse in the background. So how much of this would you say is actually an issue in some cases about enforcement as much as it is an issue about the law that we have?
Of course, there is an interesting element of enforceability in there. In most of the cases, you are completely right. There is a lack of enforceability. It's not that the law failed; it's that we fail to enforce law. Right now, coming a bit back, and maybe I can introduce now some of the elements of the particular story of Mr. Babis in Czech Republic. Because if you think about it, for those of you that are not familiar with the story, what happened basically was he acquired a very valuable real estate in the south of France, but he does this through a tax structure that it makes a lot of sense from a tax perspective. He has first of all a company in BVI, and that company holds another company, an LLC company in the United States. And that company has a subsidiary in Monaco, and is the company in Monaco who is buying the real estate. Now you think, why to do all of that? To buy a real estate? Why not to go there, write a check and buy the real estate? And there are tax reasons involved there, right? And valid tax reasons as well. Because if you think about it, from the perspective of an investor, when you are deciding how to invest, you need to decide, whether you do through capital or debt, basically, right? If you use capital, you will receive shares back, and so probably dividends in the future. If you do it through debt, it means that when they pay back the loan, they will have to pay interest to you. Those interests are deductible at the level of the payer. There is a tax benefit there, completely legal. So I want to use a tax benefit, and yes, was exactly what Babis did here. So it was a company in BVI who gave a loan to the company in the United States, the LLC, and that company also gave a loan to the company in Monaco to acquire the real estate in the end. Nothing of that is wrong. Nothing of that is bad. The only mistake there was that instead of declaring that he was indirectly the owner of the real estate for other type of laws, not tax laws, he didn't do that, right? So for all purposes, the owner was the company in Monaco. When you look at who is the owner of the company in Monaco, it's another company in the United States. When you want to make the whole story, of course, you are right that the ultimate beneficial owner is him. He should have say, I'm the owner of this. There is a lack of enforceability of I don't know, particular laws, that oblige you to disclose financial assets. Probably yes. Should that be changed in the Czech Republic? Yes. Does it make this conduct illegal? Not necessarily, not from a tax perspective. So there is a distinction, which is also very, I know that it can be very frustrating too. And this is why I emphasize in my presentation that one thing is how the law works today. And the law works in a way because we used to act in a certain way, and that's fine. But the question here is not how the law works, whether a particular conduct is legal or illegal. It's more about how we make the law. Are we making the law equal to all members of the society or not? And this is a way more fundamental.
A question of who the law works for. So thank you very much for waiting patiently, Miguel. And I see that Federica has her hand up as well. So we'll go to you two next, and then we'll come back to the chat box where I think a couple more points have come up. Miguel.
Sure. Hi, thanks, Dr. Parada, for your very helpful discussion this morning. I had a question. To what extent do you think the OECD, something along these lines, would be on the radar of the OECD in the near to medium term future? I know they have their hands occupied with the the minimum tax rate. So to what extent do you think something along these lines would attract their attention, or greater regulation would be either under consideration or to be implemented in the future? I mean, having regard to the fact that something like that, like the minimum tax rate, would have taken at least 5 to 6 years to reach the stage it is right now. What are your views on that?
Yeah, well, it's in my view, it's a topic that is it is indirectly related, but it's not necessarily the core of the discussion about leaks. If you want to know my take on the minimum tax, I think it's a major success, politically speaking, because putting together countries agreeing on an effective corporate income tax rate is fantastic. In all the years I've been working on this, I haven't seen that, and I think to achieve that agreement is per se successful. Now, I have written a lot about that, and I'm more hesitant about how that can benefit all countries equally, particularly developing countries. And this has to be also with the fact that some developing countries, they attract direct investment, foreign direct investment, through tax incentives. And I'm not talking about shell companies or businesses that they have no substance. I'm talking about real businesses. So when we eliminate completely tax competition, which is the ultimate aim of having a minimum corporate income tax level, that competition won't be eliminated in practice. It will be just swapped into other forms of competition. So in the end of the day, only those countries that are able to compete will survive. And I'm a bit concerned that some particular developing countries, they can really make that swap into some other forms of competition, because you can compete with infrastructure, you can compete with labor to the extent that you have it. If you don't have it, then the only form of competition was limited to your tax system, right? And so that would be but maybe this is a bit outside of the scope of the talk, but this might take on that. Yeah.
Thank you, Leopoldo, again. Thank you, Michal. Federica.
Yes. Hi, good afternoon, everybody, and thanks a lot, Professor Parada, for the interesting discussion. I totally agree with you when you refer to the necessity to have a reform. And I think you may agree with me if we say that the most interesting thing to do, or more be useful things to do, would be to have a sort of global reform, or anyway coordinated reforms, because of globalization, cross-border constructions, now it's very easy and to have a reform that maybe we're working in a country, but then have a gap in another one. And now my question is, today, maybe, or at least the kind of platforms that I may think may facilitate this coordination or reforming are OECD, especially for tax perspective, and FATF, especially for anti-money laundering perspective. Do you assess them as adequate platforms for further reform, or do we need something else? Thanks.
That's a very good question. It put me in a very difficult position. Okay, let me refer to what I know the most, which is the OECD. Are we still recording?
We are. So if you want to say anything off record, I can pause the record.
But it's fine, Andy. I just want to say that, okay, let me recognize that the work of the OECD, Federica, I think has been great. I mean, no one else has achieved, what the OECD has done in the last 7-8 years, with a multilateral instrument signed by more than 96 countries, with a global reform that is still not implemented, and it won't be implemented right now, but it's agreed on it. So all of that for me is 100% political success. Now, is the OECD the institution that represents the interests of all countries around the world equally? I have my doubts. I think that many developing countries, they are heard there, but not necessarily taken into account seriously. In such a way, I could say I couldn't completely take out the lead of the OECD, of all tax matters, international tax matters from the OECD, because they have a cohort of experts, which is fantastic. But I would try to perhaps, try to see how we can improve the level of legitimacy in the OECD, which is beyond of having what they have now for the international reform, the inclusive framework, is beyond of inviting countries to participate in the debate. Is about reforming how countries are part of the OECD. If you look at today, you can be part of the OECD only by invitation. That cannot be possible in a world that wants to be completely inclusive for all the interests of all countries, right? It cannot be the OECD deciding you have this particular tax measure, you need to delete it if you want to be part of our club. If we want that the OECD goes really taking a serious lead, I could definitely make some structural changes there. But I definitely couldn't take out the lead on what they have done. Yeah.
Thank you. So I'm going back a little bit in the chat box now, and Raj asks the question, and I guess it's a question that is hovering around quite a lot here, about is this a matter simply of too much power resting with too few people? And I suppose I might expand on that to say too few people of a particular kind. So I don't know what the latest figures are, but there was a time where 2/3 of the British government cabinet were millionaires. So clearly that creates a certain kind of incentive structure for them. And clearly, even in a democracy, that this is a result that you're getting through democratic processes. So there might be questions there, but then I guess we could take it on to the global level, and the issues about kind of globalization that Federica referred to there, quite useful to reflect on this, that even if that wasn't the case in a particular democracy, if you had the kind of most tight social democracy with egalitarianism kind of running through its heart, would national interests still act as a disincentive against kind of addressing these issues because of the competition issues that you've addressed? So I guess there's the kind of in-country question about too few people wielding the strings, that there's no incentive for them to change, but also then the incentives of the international sphere that they're operating in.
Yeah. As regard to your first question, I think this is strictly connected to what I tried to say with the fact of who is making the law, right? Because, for example, in the case of Mr. Bavis, if you remember the first time he was elected, actually he said we will almost cut off the heads of all tax evaders. We won't accept, people profiting. He's a billionaire, and the laws were made during all this period of time, and he is doing exactly the same, using exactly the same structure that he was against before. So of course there is this sort of hypocrisy, in the way that this information is presented, and that means the pattern is repetitive in every national jurisdiction, right? Few decide how the law should be shaped, and of course that goes in most of those cases, if not all of those cases, in the benefit of them. It happened as well in the case of the president of Chile, who was actually for two periods, two consecutive periods as president there. So, and which, by the way, when I started in my career, I worked for lawyers that they were managing his business. So I saw things, back then. The other question is, if you can remind me, the second question is mostly about the international implication.
Yeah, so the suggestion, what I wanted to do to kind of move on from that was just pick up on your point about competition, that even if you have a jurisdiction where there's completely egalitarian lawmaking within the society, would it still be in the national interest of that country to make laws of this problematic kind so that it remains, as you say, competitive in a global market for money moving around? And I mean, I'm thinking, we're not the most anti-democratic or elitist society here in Scotland, but we have huge problems with shell companies, and very little political will to do anything about it, it would seem.
Yes, that will happen, and I would say what we should try to do is perhaps not to completely avoid that countries they compete with each other using the tax system, because that is not something necessarily or per se bad. But when you use your tax system as a country to attract not real business, to attract a shell company that will be in your country with no employees producing anything to your society, that should be contracted. But there is a distinction. If you are a country that uses tax incentives to attract real economic activities, because that's a different thing, particularly if you are a country that has very low natural resources, very limited infrastructure, not much cheap labor to offer. There is a way that you need to compete, because we are in a global economy. It's how it works, right? So you are completely right when you say there is this limitation and we need to accept it anyway. But that doesn't mean that we shouldn't, or we should stop working, and limiting those gaps, that they are a misuse of these rules, right? It is difficult, absolutely. I think it's not a surprise for anyone. Someone wrote something about South Dakota and trust. If someone in the legal area has ever seen the trust is particularly interesting, because nobody knows who has a trust. It's just a trust that can have assets and you can put wherever you want. It was the greatest invention to disappear in the hands of something else. But yes, so it will be difficult, but we should not stop, trying to do it.
Yeah, excellent. Okay, well, we're coming to the last 10 minutes of the session. We've still got some questions in the chat box. So Sapna has noted this kind of example of the kind of tourist homes there. And she's asking whether the covert practices are actually resorted to because tax law is working and competition law is actually working. That this is a sign that if people are having to go through such circuitous routes to avoid these, is that a sign that actually the legal framework is in one sense quite sound?
That's yes, it's true. It's true. And this is again a demonstration that countries they make laws that allows particular transactions to take place, right? If we didn't have South Dakota offering you a particular option, if we didn't have I don't know, Switzerland, offering you some possibility, if you didn't have, the United States saying, set up a company here and treat it completely as inexistent for tax purposes, which happened. Nothing of this could be possible. But still, it's up to those countries, to decide on their own interests why they do that. So yes, the issue is how we stop that. we cannot tell all countries to have all similar rules and stop thinking about the national interest. That could be completely unrealistic, right? But what we could do is to say countries, you are not allowed to do that to the extent that what you are attracting is an empty box. It's something that has no substance. If you are doing this particular law or a particular tax law that is attracting a real business, you can do that. Actually, that is beneficial. Probably it will imply that some employments are created there. But if you are just doing this because someone will come from the Czech Republic to set up a company here, he will never appear here, and through that company will acquire a major real estate in France, then there is something that should be done there, that should be changed there. That's how I see it.
Okay, and the last question in the text box at the moment is from Valeria, who is saying that because we have got these countries, a number of countries with policies or practices that encourage these loopholes for international companies. Again, we're coming back to this kind of, there are countries that do see this as being in their interests. What is the best policy response? So only a small question, we're not expecting much of you there, but maybe in your experience, what has worked best, or what is on the table at the moment that has a chance of addressing this?
Yes, I think, Valeria, that unfortunately there is no magic formula, because each of the transactions should be seen, you know, in their own nature. I think there was a huge progress since the establishment of the OECD-based erosion and profit shifting project, as I mentioned before, in 2013. This is not a mandatory thing for countries to implement, but curiously, immediately after that happened in 2016, the European Union implemented a directive with most of the measures that they were recommended by the OECD, and the rest of the world followed up on that. So that shows that something can be done in that direction. Now, are all those measures necessarily or effectively targeting these loopholes? From my tax expertise, I could say not necessarily. It really depends. It's a bit more complex than giving a magic formula, but it's a step, a positive step forward, in my view.
Excellent, thank you very much. There are a few more minutes if anyone has kind of a remaining question for Leopoldo. Do just raise your hand. I think, I mean, it's been a fascinating session, Leopoldo, and I think it represents a lot of the challenges that are here. And I mean, I think these are challenges that you've been speaking about them in terms of tax law, but we can think about parallels in terms of movement, not just of money. We could think about dual use technologies as facing the same issues, that, you know, there are batteries that have perfectly legitimate uses, but they also happen to fit into weapon systems. And so how do you facilitate the appropriate movement of technology for legitimate reasons while stopping technology falling into the hands of people who may use it for nefarious purposes, shall we say? So I think it's interesting to hear about the tax situation, to think about the parallels that there are, because at the heart of this, we do live in a global world, and movement of goods and money have a lot of benefits. So those are things that you don't necessarily want to come crashing into and destroy by overly restrictive legal frameworks, I guess.
Absolutely, and if you allow me to say just one more thing before we wrap up. Of course, these issues are way more complex than I have presented here. But I think, and it's very important always to see this big picture, and beyond the technicalities, beyond the specificities of what is within the content of the Pandora Papers. The big picture is that we have in front of us a series of transactions that are generally legal. So the question is why? what we do about it, what we do with this particular pattern that is repetitive. So that's the big picture that we need to take away from all of this, more than focusing, whether in the case of Tony Blair, the law allowed that, why we are discussing that now, if in this particular other case, the law also did that. I think this is beyond that. Is how this is being repetitive, and what we do with that is from that will depend our future laws. So that's the whole thing.
Excellent. Well, I would like to invite everyone to offer up a round of virtual applause to Leopoldo, to thank Leopoldo for his generosity and his time in coming and sharing with us today, and to thank you as an audience as well for your participation. So I'm going to cease the recording now. Thank you.